I have never wanted people to be represented more than I do in this AI era because the lawyer on the other side can at least tell their clients what's realistic in an accommodation scenario. It's somebody who can explain you're entitled, for example, to reasonable accommodation, but not perfect or preferred accommodation.
Workplace law is complex and constantly changing. It can be hard to keep up, and the risk of getting it wrong can be costly for businesses. The Coffee and Law podcast is here to help HR professionals and employers stay informed. We'll cover what's changing and how to navigate real workplace situations and everyday people decisions. So grab your favorite warm drink and join us for engaging, practical, and educational conversations with top experts in workplace and employment law.
This podcast provides high-level general information. The perspectives shared by our guests are for educational purposes and do not constitute legal advice. If you have a specific question or concern, please consult a qualified lawyer.
Hi everyone, it's Amy Davies, founder and CEO of First 30 and also your Coffee and Law podcast host here to remind you that First 30 offers career transition and outplacement services. So if you have terminations and layoffs coming up, this is a really good way to mitigate risk to your business and help your exiting employees recover from the job loss and get back to work. You can find out more information at www.first30ready.com/outplacement, or you can reach out to me, Amy, AMY, at first30ready.com. All of our programs include live coaching and a year of access. And in a tough job market, that can be very important. Now, back to our show. Welcome back to Coffee and Law, everyone. Very happy to have Neena Gupta back of Gowling. Whoa, what's wrong with my speaking today? Gowling WLG. This does not bode well for the rest of the episode, Neena, if I can't even get that out. But thank you for joining. I want to just say a very quick thanks to HR Law Canada, who are our partners on the podcast. They're amazing. If you haven't had the chance to check out HR Law Canada's content yet, I really recommend a visit. We are going to be talking about accommodations today. And Neena, I don't know if you've noticed, but they tend to have a lot of great articles on this topic and many more related to all of the things that we talk about on this podcast. So definitely go and check that out. And of course, please subscribe to our channel. Give us a like, give us a 5-star rating if you're listening. We really do appreciate it, and it goes a very long way. The podcast is really growing, and we thank you all for your support. And one more organization I want to thank is Storyfora, who does the production for our podcast. They're so great to work with. So with all that out of the way, Neena, I'm really interested in this topic. It's one that's coming up more and more. People are learning, quite rightly, how to advocate for themselves in the workplace more and more. And then that means that employers are noticing things and often doing what needs to be done or what they think is the right thing to do. But they're also getting a lot of requests for different accommodations that potentially haven't been coming in before. So I think this is a really important episode. And I think it's also good to tune in as an employee as well. You might learn a lot from this content too.
Absolutely. I think that some of the hardest work that I do is dealing with issues of accommodation and what is fair and reasonable in the special circumstances that the employee has put on the table.
Yeah. And I really want to start the conversation by asking, what is the legal definition of accommodation? Because we hear it coming up, as I said, more and more in the workplace. But when does it actually apply and what does it mean?
Okay, so let's start with a little bit of Law 101. So,
Okay.
Law 101, I'm going to try not to make it boring, is that the idea is that within certain reasonable limits, an employer has the right to set the terms and conditions of employment. When does work start, how it's done, when it ends, whether you do it in the office or on the road or from your home, what kinds of duties you have, whether you're working in the warehouse or typing in the typing pool, if we even have one of those anymore. It is the employer's decision to say, I need a person to do this set of jobs and tasks. And that was the norm. Now, what happens if somebody can do, quote, the essential duties of their job, unquote, but cannot do certain ones because of a legitimate reason? And a legitimate reason is a human rights protected ground, which could include family status. I can't start work right at 8 o'clock because my daycare doesn't open till 7:30, and with the commute time, it takes me an hour to get into work, and therefore I can't get in before 8:30. So even though the employer has the right to say your shift's is 8 to 5 or whatever, there's a request for accommodation to start half an hour late. It could be somebody has a temporary or permanent injury, so a disability, which means that they can't perhaps drive or lift or carry the way that you would normally expect. And is there something we can do about that, either temporarily or permanently? So I used to joke, but it's actually true. Almost every written or unwritten term or condition of employment could theoretically be considered a barrier to somebody who has a legitimate protected ground, right?
Mhm.
So then the question is, how much of the employee's circumstances that are protected by law, such as their family circumstances, their health, religious observations, can we accommodate? How can we change how the job is done, when the job is done, what tools are used so the person can continue to do the essential duties of their job to the reasonable satisfaction of the employer? So accommodation refers to that whole process and also to that those changes that we might elect. So, for example, if I have an assistant who might need some accommodation because they have some elder care responsibilities or some health issues, can I give this assistant some flexibility in hours? Now, that might be easy to do in a law firm where it doesn't really matter to me personally whether something gets done between 2 and 3 o'clock and 5 and 6 o'clock. It doesn't matter. But what if you're in an assembly line and she's a widget maker and she has to make her widgets from 8:30 to 3:30 so that the evening widget finishers come in at 3:30 and finish it till 11:30 so that the distribution people pick it up at midnight and distribute it for the next morning. Then it becomes a much more difficult analysis, right? Because then it might be interfering not just with how she gets her work done, but also with others. And that whole process of thinking that through is an accommodation process.
Now, just I'm sure people listening are like, there are just so many questions that are popping up just based on this one little piece of the conversation. So I do have a question around what if you started in a job? I'm thinking of someone, let's say someone who makes deliveries for a company, and that required as part of their job, they're required to lift heavy items to deliver to customers, okay? Now, I know we're going to talk about what happens if you're injured at work, but let's set that aside for a moment. You, over time, develop a really bad back and you can no longer lift the items that is it's part of your job. So effectively, you actually can no longer do your job. Your employer only has that job for you. Now what happens?
So let's just unpack that a little bit because it is a workplace injury. And so while we don't have every province has a workplace insurance program, there are different
Sure.
obligations or additional obligations, if you will, that you need to be mindful of when it's a workplace injury. But let us take that, and I've actually had that scenario. Some delivery companies have essentially routes that are known to be heavy, i.e., you're delivering cases of bottled water and soft drinks. And so those are notoriously heavy, but they also have light deliveries. And so the first thing you look at is, can you change up the route so the person is doing less heavy work? Is there some work in the warehouse or in the office that they could do? Because it's not just, you first look at whether or not you can accommodate into their old position, but then you also look at whether or not there's any available positions that they could be accommodated into. It's only when you've gone through that process and you have to almost show your homework. It's like, grade 10 mathematics. It's not enough to know the answer. You have to show how you got there. And you have to have a
Sure.
conversation, especially in Ontario, where we have the Accommodations for Ontarians with Disabilities Act. There's a procedural obligation to have a conversation and engage with the employee to discuss what they think might be a good accommodation and to see what it is. Now, one accommodation we haven't talked about yet is giving people leaves of absences because maybe this person deserves to be on either a workplace injury leave or just a short term and long term leave to allow their back to heal up. And we keep their job open. Maybe backfill with a temp or a summer employee while the person is healing. So, one thing we have to really, really grapple with is this a temporary accommodation? Or is this likely to be permanent? And the analysis is very different because if something is permanent, it's really hard to say, oh, I'll give them a permanent leave for the rest of their life. Like that's not going to happen, right? But but if it's like, the doctor says it's going to take 4 to 6, months to heal, and maybe it's a knee injury, that's why it's not working, but once the knee surgery is over, then you might have a different analysis because you might be able to give a leave. It may be an unpaid leave if it's not workplace. It may be a paid leave through WSIB or WCB, depending what province you're in, and then the person comes back. So we need to think about leaves and we need to think about alternate jobs and alternate ways of doing the job. Like, so maybe is there a way of having a different kind of cart that takes on more of the weight so the person isn't handling all of that weight all the time. For those of you who are listening from Waterloo Region, you will know that Waterloo Region just went to the automatic garbage bins. In other words, the bins are standard sized, and the garbage truck has, clamps, and they pick up the bin and empty it themselves. Well, that reduces the back stress enormously. That's one of the reasons why those are very attractive to municipalities because it completely reduces that chronic back stress that you see. So all of this has to be thought about, and it gets very confusing and very difficult for HR. So I have two tips. One is document everything, and don't be afraid to ask for more information. And finally, get outside help. There are people who know way more than, quite frankly, your lawyer or the doctors about assistive devices and accommodations, and they can be really helpful about getting people back to work.
I think when people say the word accommodations, sometimes everyone kind of uh, panics because they think, "Oh my goodness, it's gonna be so expensive and complicated." And then it turns out it's so simple and inexpensive to make the accommodation, and all that worry was for naught. Now, I made a little mistake when I was talking because I did realize that I brought up someone making deliveries, and they could claim, rightfully so, that that happened on the job. So that was a bit of a disconnect. Now, what if someone has been injured outside of the workplace and needs an accommodation inside the workplace? How does that change things?
Okay, so take your example, which I don't think was a misdirect. I think it was really important to identify that employers have special obligations under the workplace compensation systems of their province, because quite frankly, the longer an employee doesn't work, the more expensive your insurance ratings get. And there are additional duties to return people to work under various regimes. But let's just assume it's your scenario. Your second scenario is, somebody was out playing hockey and got really badly injured. They've injured their back and now they need accommodation. That, under the Human Rights Code, is still an illness or disability that deserves accommodation. Obviously, it's not going to trigger workplace compensation, reporting duties, or other return to work obligations. But your general duties under the Ontario Human Rights Code and its sister legislation across the province is the same. You still have to accommodate to the point of undue hardship. And what is undue hardship, of course, is in the eye of the beholder.
Outplacement and career transition support make a real difference for employees experiencing terminations or layoffs. Offering these services also reduces legal and reputational risk for employers. All of First 30's outplacement programs include access to a live coach, along with 1 year of access to our career transition portal, job search resources, and much more. Programs start at $985 per participant. You can find information about our programs and pricing at first30ready.com/outplacement, or reach out to us anytime at info@first30ready.com. Speaking of being in the eye of the beholder, what if you're challenged with a situation where you have an employee asking for an accommodation that you don't sense is legitimate? They might feel it's legitimate, but I guess just like what is the threshold, and how, and you mentioned don't be afraid to ask for documentation. What is the employer entitled to do in a situation where they're like, okay, and I'll give you an example. So there's a lot of debate about back to the office, right? And, there's people who feel they have a legitimate claim to work from home, even though, let's say, Neena Gupta has worked with the employer on their employment agreement, so we know it's absolutely picture perfect. um, but they are asking for accommodations to work from home, and it's doesn't just something's not sitting well. It just doesn't feel like an appropriate accommodation to give in an employment situation where you actually do need people in the office a certain times in the week or all week potentially.
Post COVID, I'm seeing a lot more requests for work from home because more work can be done from home. There were things that simply could not have been done from home in 2019 that we can easily do from home in 2025. Work from home, in fact, is a legitimate type of accommodation. It isn't necessarily a right of the employee, but it's definitely one of the accommodations an employer should look at. So you look at, well, why is the employee requesting accommodation? Is it a health reason? In which case, we can ask for health documentation either from the healthcare practitioner, or if you're really suspicious, pony up, get an independent medical evaluation to see whether or not this is legitimate. Many of the cases.
Can I ask a question, just
Sure.
that I think people listening might have, about the documentation? What type of documentation would be considered sufficient? Because I think there may be a lot of confusion
Sure.
around that.
So you are not entitled to diagnosis. So I am not entitled to know whether the employee's medical restrictions are caused by, let's say, sexually transmitted disease, cancer, or like an actual, a fracture. I may be entitled to know generally whether it is a mental health issue or a lower back issue, but in general, we're not entitled to the diagnosis. What we are entitled to are the medically established limitations. And what I really strongly encourage employers to do is to, instead of send a standard form, create questions you want answered. And they typically are something like, what are the medical restrictions that you've observed? I don't want to just have a doctor regurgitate, my client, my patient says, what have you observed? How long are they likely to, last? Can we expect some improvement? And if so, in what time frame? Um, you're asking for the restrictions. What are the restrictions? So sometimes the restriction can be, you know, um, is not able to drive or is not able to work at heights because of balance issues. We're not entitled to know whether the balance issue is due to a brain cancer or Meniere's disease or something else, but we are entitled to know that those are medical restrictions. Now, the person may say, that means I have to work from home. Your response will be, well, there's public transit. And so there may be a conversation about what is appropriate. I've had situations where employers have correctly said, when it's, let's say, not medical, a lot of the times it's family care obligations, right? Like daycare, elder care. I've had employers say, look, we will give you a temporary accommodation 3 months, 6 months, but our expectation is that you will find alternatives to your current situation so that you can, in fact, come into the office because there's office work to be done. During COVID, I had a very specific example where somebody used to live in Kitchener, decided that this would be a great opportunity to sell their Kitchener home and move permanently into cottage country. And I can't even remember where cottage country was, but it was not commuting distance to Kitchener Waterloo. And then she essentially said, well, I now need accommodation because, I'm finding the 5 hour a day drive to be, physically very difficult
I
because
bet.
I'm sure it
Yeah.
is. And we essentially said, well, we'll give you that accommodation, but you're going to have to change. Your decision to move out of the city was not because of us. You made that decision. So we'll give you a reasonable time to move back into within reasonable. And that essentially helped broker a settlement. So we have to be a little creative. But remember, undue hardship is a very high standard, and essentially, it typically ends up meaning it's too expensive, or we're going to have to hire somebody either part time or full time to do part of the job, or she's really not doing, or he's not doing the essential duties of their job. So if you've got a receptionist and they want to work from home, and a part of their job is greeting visitors who come in person, setting up the boardrooms, cleaning up, lunch and dinner plates, showing the caterers where to do it. I mean, all of that work could probably be split up with other people, but that's the person's job as receptionist. And so if she can't do those essential duties, you may have a situation where she goes on leave for a while, or he essentially ultimately, we have a situation of frustration of employment.
Yeah, and it's funny to say, but I think that, AI tools even make it more complicated because people are probably getting a lot of their education about all of this from AI on both sides, I
On
hate to
both sides,
say,
like
and
yeah, I use AI, Amy, I love AI, but AI
yeah,
is a
yeah,
great
yeah.
tool when it's used by a sophisticated user because it does generate a lot of junk. I've had cases where AI gives me this wonderful brief, and I'm going, oh, and then it refers to a case that I happen to know. Like I actually argued the case, or I presented on the case at a bar association meeting. I'm like, I don't remember that from that case. And then I look, the case has nothing to do, but AI cheerfully put it in and really like because it's so beautifully formatted and it's so well articulated that it's persuasive. And then you're looking at it, but it's a bunch of hooey. The problem with AI is
Yes,
you get a
yeah.
lot of letters or demands that are generated by AI. And I know every HR person is struggling with a volume of work where, yes, you can generate a garbage claim via AI, but our response has to be accurate.
It does empower people too because they think this sounds articulate, this sounds like something that will pass. But then experts like you come in and you're able to make sense of it and help people. They may even get information that's not from the jurisdiction that they're in, right? Or the province or state that they're in.
And a lot of people are getting AI that, no fault of their own, is relying on American sources. And as you may know, American damage awards tend to be significantly higher than Canadian damage awards. In the Canadian Human Rights Act, for example, there's effectively a $40,000 upper limit on awards. financial awards, right? That's a very
Okay.
low limit.
Yeah.
While in the States,
Mhm.
multi-million dollar judgments are not unheard of. So I'll see a demand letter for, you failed to accommodate me and now I want $1 million. And the person doesn't have a lawyer. I have never wanted people to be represented more than I do in this AI era because the lawyer on the other side can at least um, tell their clients what's realistic in an accommodation scenario. It's somebody who can explain you're entitled, for example, to reasonable accommodation, but not perfect or preferred accommodation.
Is there like a top 3 of the most common accommodations that are requested that, employers should really educate themselves on that you can think of?
Ye-
Maybe that's a very difficult question, but
yes.
I would think work from home would be the one of the top ones.
So, one of the ones that I find people struggle with is the pregnancy accommodation. And in I've had situations and in workplaces that are blue collar that essentially take the position, well, it's not our fault you were pregnant and it's something you voluntarily did. It's not like an accident you suffered, so it's not our problem. If somebody has a pregnancy related medical condition that needs accommodation, it's treated like any other illness, like cancer or a broken leg. And the fact that the woman wanted to be pregnant and have a child does not alleviate the employer from the duty to accommodate. I didn't think I would have to explain this, 35 years after I started practicing law, but that one is one that people still seem to struggle with. Secondly, family status accommodation, child care accommodation is in fact a legitimate reason to ask for variation. So the fact that our school system tends to work from 9 to 9:30 to 3:30, that childcare is difficult to find, that people don't always live in a jurisdiction where they have family support. And even if they have family support, though family members may be working, so they're not available 5 days a week, that may need accommodation. The third is
Mhm.
when there are ill members in the family. People are very sympathetic and understanding when the employee themselves is is facing a health crisis. But we also have a duty to accommodate when employees are the caregivers or emotional support for children, spouses, and parents. And so there is a duty to accommodate. And we see changes to both the Employment Standards Act, workplace compensation systems, and to human rights jurisprudence to try to remind employers that employees have lives and that while you still have a right to expect an honest day's work for an honest day's pay, you also have to accommodate the whole individual. I think 100 years ago, that would not be the case. The case is, this is the job, you take it or leave it, and if you don't like it the way it is, just leave. That is not the case in 2026.
Well, and this might seem silly and a bit self-serving because as you know, I'm very proud people parent, but I'm also very proud pet parent. And there's people are waiting to have kids, not having kids as much, and their pets become their children. Ask anyone how enthusiastic I am about my dog Jagger. Is it a legit I mean, it might seem like a silly question, but it's being asked in workplaces. Are there any accommodation entitlements for pets at this point, and what do you think
Uh,
future will hold?
so, to the best of my knowledge, while we have all sorts of leaves for human members of your family, you do not have that for the pet members of your family yet. Smart employers have flexible paid time off arrangements where people can use some of that paid time off to take care of your four-legged family members. And absolutely, people are extremely close to their four-legged family members. And I remember when I lost my first cat and I was at work and I was just a basket case and I was just really mad that I just couldn't focus. And it was my friends at work said, look, that's a member of your family and that you've lost. Just go home and just take a moment to breathe,
Yeah.
right?
You needed your bereavement
I
leave.
needed my bereavement leave and I just needed just to kind of process it, right?
Yeah. Well, I have one more question for you, and then I'd love to hear our spill the tea. But my last question is, are there any decisions or emerging trends that we should be aware of when it comes to accommodations, or are we sort of where it is where it is right now? We don't know what's coming next.
I think the trend is that employers are going to have to justify when they say no, right? They're going to have to show
Okay.
that, they really tried and sincerely tried. And only after all those choices failed did they say no. And then they went to the next step. And that no could be, okay, you're going to have to take a leave or this relationship isn't viable. The other thing you need to maybe think about is what job the employee has makes a real difference. There's a real understanding that if somebody's a CFO, a CEO, a general manager, we may need to replace that person very quickly because the business cannot survive very long without a CEO, CFO, or senior operations manager. If the person's a receptionist, a warehouse worker, or a driver, there's much less sympathy about saying, oh, well, we couldn't possibly hold their job open and get a temp. Of course, you can get a temp for somebody like that. May not be as good as the job you could get otherwise, but there are solutions. So, position matters, and that's coming out in the case law very clearly. So, do your homework and
Yeah, document that. What I'm hearing is document, document, document,
yeah.
and then document again.
Yes, and
Okay.
get your help, get your lawyer, get your consultants in.
Get your lawyer always. Yes. Now, I need my spill the tea. I need some tea, Nina.
Yes, you need some tea. So, well, I mean,
Yeah.
I wanted to well, when I tell the story, I want everybody to know that most, accommodation requests are completely legitimate. It may be that what the employee proposes is a little bit too much, but the actual basis is legitimate. But
Hmm.
my favorite
Sure.
story is somebody who, claimed to need childcare, accommodation, but was really using that as an excuse to go travel, back to their home country, and in fact, was working remotely from a different country, and the company had you can work remotely, but you have to stay in the province of Ontario policy, and they were pretty clear about that. They might allow a week or 2, but they wouldn't allow more. But they use "Oh, I need to work remotely because I have childcare issues that are really difficult," and then the company found out that the person was actually working from a jurisdiction they would not have been permitted to work from, and it was the IT officer who said, "Do you know why we're getting all these, logins from a internet address that's in India?" And that's how we caught it. So I just thought that was a fun one where there may have been some, and they say, "Well, I had childcare in India, and that's why." But you didn't disclose that you were getting your childcare in India, where you knew we had a policy that you couldn't work outside of the jurisdiction for various reasons. So, most requests are
Wow.
legitimate, but every so often, employees try to push it a little bit.
Well, I just reminds me it's very different, but uh, there's a through line here with the pets. But if you ever watch a show Veep,
Yes, of
and
course.
she had someone on her communications team who was always having to leave early because he needed to take care of his dog. He didn't even have a dog, it turned out. So spoiler alert, but it's been, that show's been finished for
Yeah,
several
yeah, if you
years.
don't
But
know that
yeah,
plot line now, too bad, so sad.
yeah. Well, it just makes me think of it's funny, and I agree with what you're saying though. 95% of the requests people are making are absolutely legitimate and need to be thoroughly reviewed. and in many cases supported for sure. But that I thought that was just a really funny part of the show. It perfectly fit with this character. Well, listen, thank you so much, everyone, for listening. Neena, as always, thank you. And I'll also make sure to mention our partners again, HR Law Canada, and our wonderful producers at Storyfora. Uh, until next time, we'll look forward to seeing you. Take care.